Robert Krajcik reporting for Rebel News here in Ottawa, Ontario, at the conclusion of day 26 of the trial of Tamara Lich and Chris Barber. The two co-defendants are being charged with a series of crimes associated with their roles as organizers in the 2022 Freedom Convoy. You all remember it. It was a peacefully disobedient demonstration here in downtown Ottawa against what I call the COVID-19 enterprise, mandates, edicts, decrees, special orders, and lockdowns. Now, we got to speak with Lawrence Greenspan, Tamara Lich's attorney, very briefly. We got to speak with Adam, a lawyer with the Democracy Fund, to give us some of his insights about today's proceedings. But before we get there, I just want to remind you folks out there that we need your financial support to continue delivering this important journalism to you. So please visit tamaratrial.com, help us out, and also stay up to date with our ongoing coverage.
Come on out November 25th. It's all aboard the Freedom Train in Niagara-on-the-Lake. You can check Rebel News for updates and also the Freedom Passport site.
Tamara Lich, who led the truckers' convoy, will be sharing the stage with some of the finest international recording artists, like the Chops Horns from New York City, who's played with Alicia Keys, Stevie Wonder, the Rolling Stones, and many more. Plus New World Sun, just off a European tour, and the legendary R&B master, Leroy Emanuel. Get on the Freedom Train with Tamara Lich. Saturday, November 25th at Niagara-on-the-Lake Central Community Center, 680 York Road. Get your tickets today at freedompassport.ca. The Freedom Train is coming. Know your rights, know your freedoms.
For you folks that have been following our ongoing reports here from the trial, you may recall that there was this ongoing disclosure dispute between the Crown and defense teams regarding emails sent between Ottawa Police Service officers that were claimed to be privileged and protected via solicitor-client privilege by the Crown at the behest of the Ottawa Police Service. In other words, these emails that were being sent between Ottawa Police Service officers were being sought to be fully disclosed by the defense teams, and the Crown rejected that with redactions saying that these emails should be shielded from disclosure because they contain within them protected attorney-client or lawyer-client privileged communications. So what did the judge decide today? She decided that she would remove some of these redactions and keep others. Now, why was this dispute noteworthy? To start with, the emails themselves do not involve any lawyers as direct recipients or senders. And the test for solicitor-client privilege requires that lawyers themselves be offering privileged guidance or counsel to their clients. But the judge accepted the Crown's claim that even though lawyers were not directly parties to these emails, the police officers were discussing amongst themselves legal counsel that they had received from their legal department. Now, the major rationale that the judge provided for removing several of the redactions is that after reviewing these emails herself, she said that these redactions were applied to remarks and analyses, opinions from police officers themselves, rather than simply directly relaying what they had been counseled to do by their legal department. In other words, if police officers are talking amongst themselves about legal counsel they've received from their legal department, and they're opining on what they've been told or guided to do, that in and of itself is not protected or shielded from disclosure via solicitor-client privilege. Another disclosure dispute that was addressed but not resolved today relates to a bunch of text messages sent from Chris Barber's phone. Now, the Crown in this case is seeking full disclosure of these texts, and the defense is seeking to withhold some of those text messages. Now, my understanding is that the Crown has already seen all of these text messages because these text messages were sent from Barber to Ottawa Police Service police liaison team officers. But what the Crown wants to do in terms of this disclosure request is allow for these text messages that are being disputed to be allowed to be admitted as evidence in this trial. Now, this is going to take a while to resolve. It's something like 1,100 pages. I think something like 100 plus of those pages are in dispute. And Diane Magus, the defense attorney for Chris Barber, today said towards the end of proceedings that if they're going to go through this text by text in terms of those that are disputed with the prosecution, it might take 2 full days of proceedings before that in and of itself is resolved. Now, why does that matter? Because the two defense teams don't want to proceed with their cross-examination of any other witnesses until they have this resolved. Lastly, this trial is going to go on a significant break going forward. The next dates of proceedings have not yet been established. We anticipate that it will be sometime in December. So that is to be determined. These proceedings just a few moments ago.
Yeah.
What were you referring to in terms of a resolution between yourself and the prosecution? Or
These are other cases, not this one, that are outstanding, in which defense counsel are involved for other accused persons. And there's been discussion about resolving those in order to try and free up some additional time for this case.
Okay, I've got one other question. When you were at the end of the proceedings again, remarking on the difficulty in securing dates and how you've got a bunch of other responsibilities you've got to juggle to make things coordinate properly, I'm just wondering if you, over your legal career, you've been doing it for at least a while, have seen a sort of degradation of administration of the judiciary. Is it more difficult to get dates? Is there less availability relative to demand than maybe 5, 10, however many years you've been practicing?
Well, there's no question that judicial resources are stretched thin, and that's one of the reasons why this case is we're having difficulty finding continuation dates. Certainly, if the judicial system were more responsive to the realities of what has happened in this country in the last 10, 15 years, then the resources would be made available so that this and other trials could proceed in a more timely fashion.
Just to emphasize, you said that the resources are thin, but have they been thinning over time?
I would say that it's at both ends. There's been an increased demand. There's more cases. The cases are taking longer, and at the same time, the resources for the judicial system have not been for the justice system have not matched the growth of the volume of the cases that are coming before the courts.
Why don't you tell us about the judge's decision today regarding these disclosure disputes?
Sure. Perkins McVeigh today decided on the solicitor-client privilege claim that the Crown made to redact a number of, portions of a number of emails that had the subject line of PLT disclosure. In essence, her decision was that some of the redactions were unwarranted and others were warranted. Yeah, basically meaning that she's going to disclose a number of the redactions that the Crown claimed as solicitor-client privilege.
Now, what about the rationale, the grounds for her decision? Can you show the audience what the judge said in terms of why she's deciding to remove some of the redactions that were initially implemented, as you put it, by the Crown?
Yeah, so she's just following the solicitor-client privilege test, which basically states that there has to be a solicitor and a client involved in a discussion. The discussion has to be confidential, and the discussion has to be for the purposes of receiving or obtaining legal advice. So she found that the portions that she's going to be unredacting did not meet that test.
If you folks out there in the audience appreciate our in-the-field reports, please understand that we need your financial support to continue delivering this journalism. So please visit tamaratrial.com and contribute if you can, and also stay up to date with our ongoing reporting.